So good afternoon, notaries. Thanks very much for joining the BC Notary Association on your lunch for today's Lunch and Learn. You'll notice we're using a slightly different format today. As I said, as some of you were logging in, we wanted to try and use Zoom meeting as opposed to Zoom webinar, which is what we normally use for these. And we did that so that following segments of Dr. Hall's presentation, we can ask you to raise your hands electronically, and you should be able to do that if you move your cursor, or sorry, your mouse down below under reactions. There is an option there to raise your hand, which I've just done, and then also an option to lower your hand once your question has been addressed. So Trista is going to monitor the participants to see if a hand is raised. And Dr. Hall will provide us with opportunities in between segments of her presentation to ask questions. So this is a bit of a trial for us. I want to thank Dr. Hall for allowing us to do that. And I would ask that members please remain muted with their cameras off for the presentation. At this point, I'll get ready to turn things over by introducing Dr. Hall, who I'm sure all of you are well familiar with. Dr. Hall is a professor and BC Notary's Chair in Applied Legal Studies in the School of Criminology at Simon Fraser University. Margaret's research interests include law and aging, mental capacity and undue influence, legal responses to vulnerability, and systemic theories of liability and tort law. Margaret's research integrates doctrinal analysis with qualitative research methodologies. Prior to joining SFU, Margaret was an associate professor in the Faculty of Law at Thompson Rivers University and an assistant professor in the UBC Faculty of Law. Margaret has also worked in law reform and was the first director of the Canadian Centre of Elder Law Studies. Margaret's going to speak today around some general updates, from Simon Fraser and the MALS program, and then we'll pause for questions, and she'll move into a piece of case law that she'll discuss with you, and again, pause for questions on the conclusion of her presentation. We'll turn things at that point back to Trista, who will wrap up for us. So with that, Margaret, I'll turn it over to you. Thank you.
Okay, thank you, Chad. So many of you will have encountered me through my involvement in the Applied Legal Studies program. I became the director of that program in September of 2019. Wow, time has gone by very quickly, taking over from the esteemed Rob Gordon, who of course it was under his guidance at SFU that the program came into being. So I've enjoyed my time as director, certainly made a little more challenging and hectic by the unexpected COVID developments that happened last spring, but I think that we've weathered that storm pretty well. So I wanted to let you know about a couple of things that have happened in the last year. So Ron Usher, who has been an incredibly important part of our program for many years, decided to retire from the program this year. And so we actually had to recruit 3 new faculty members to take the place of Ron. So that kind of demonstrates the extent of his contribution to the program. So starting this fall, Katie Sykes, who is an associate professor in the Faculty of Law at Thompson Rivers University, took over teaching the Property 1 course. And 2 lawyers with Alexander Holborn, Anil Agarwal and Andrea Famartino, are going to be taking over the Property 2 course, which is going to be starting quite shortly in May 2021. So many thanks to Ron, of course, and welcome to Katie, Anil, and to Andrea. Now, we had another retirement this year. Elle Lecoq, who has taught the contracts course in the program for a number of years, decided to retire from that position as well. And so Rob Rousseau, who teaches at the Allard School of Law at UBC, was recruited to step in and take over the contracts course. He is currently teaching that now in the current term. So welcome to Rob. So it's been quite a dynamic time. We have lots of new faculty members, and I can report that they have all told me that how much they've enjoyed teaching in the program, and especially how much they've enjoyed the engagement level of the students. Now, also coming on this year to teach ALS 601, who people that have participated in the program will remember is the Canadian Law and Legal Institutions sort of introductory course that's given in the fall. I taught that course for several years. So starting this fall, Professor Helene Love, who is also a professor in the School of SFU School of Criminology, took over that course. And she has certainly told me how much she has enjoyed teaching that course. So those are some of the faculty changes. As some of you will be aware, the upcoming Scrivener edition, the notary publication, includes a special focus on education. And so each instructor in the program has participated a piece for that special edition, saying a little bit about their course and also highlighting some recent legal developments of interest in the area of law that they teach in. So I think that should be hitting the printing press, or however these things are produced these days, shortly. And I'm really looking forward to that. I think that's going to be a really great issue. So those are some of the changes that have taken place. Another thing I wanted to highlight for you is that I have been thinking, now I've kind of settled into this role, of making some course changes within the program. One of these is that one of the courses that I teach is personal planning, which incorporates both wills and estates, and also those instruments that we refer to collectively as incapacity planning. So that means powers of attorney, advance directives, and representation agreements, all of which are within the scope of notary practice. And I'm also aware that there have been some developments in relation to medical assistance in dying and the possibility of advance requests in that area, which may become relevant to notaries. Again, that's something that is kind of, as I'm sure we all know, a bit of a work in progress. Lots of changes going on right now, but may need to incorporate some of that information into that incapacity planning section of the course as well. Now, having had a chance to review all of the courses since assuming this new role, I've realized that I think since this course was first introduced, I guess 14 years ago now, or 13 years ago now, the law around incapacity planning has really grown in significance and also in complexity. And so when I look back at how the course was originally delivered, I see that there was really very, very little about incapacity planning. And over the years, of course, the amount of the course that we've had to devote to incapacity planning has increased in connection with the increase in law in this area. So for this reason, one thing that I'm about to initiate, but if anybody has any ideas about this or feels like giving me some feedback about it, I'd really appreciate it, would be to kind of separate this course, the current course, into really two new courses. One of which would focus more deeply on incapacity planning. And I think we could also include a more in-depth focus on mental capacity within that new course. And another course that would focus more specifically on wills. And indeed, the law relating to wills is itself kind of increasing and becoming more complex, certainly with the introduction of e-wills currently within WESA. And my understanding is that we'll see more provisions introduced within WESA that will be dealing with different aspects of e-wills as well. So that's something that keep an eye on for the future. As I'm sure you can imagine, it takes some time to process course changes through the SFU administration, but that's an upcoming change that I think will have a positive benefit on the program. Now, I'm interested in feedback about that. And I'm also always interested in any feedback that anybody has generally about the program, because I really am committed to making the program the best that it can be. So feel free to contact me at any time with any thoughts that you might have. So I'm going to pause now and see if anybody has any questions relating to this part of my discussion with you all today. And then my idea was to talk a little bit with you about this case, Estate of Le Galley, which is one of the cases that I talked about this term with my personal planning students in the section of our course that talks about gifts to witnesses. And I thought it was a very interesting case, and also one that would be of interest to you, to sort of the more general population of practicing notaries. So I'll stop now and we can have a bit of Q&A if anybody does have any questions. And after that, go on to talk about Estate of Le Galley.
Thanks, Dr. Hall. So I know Trista is going to look for raised hands. And just a reminder, folks, I know a number of you logged in after Dr. Hall had gotten started. Please feel free to turn your video camera off and mute yourself. Unless you've got a question, you can raise your hand virtually under reactions. And Trista, if you want to do a quick scan for anyone with their hand raised and call on them to feel free to ask Dr. Hall a question.
Yeah, I've been scrolling, just trying to be prepared for this new format. Thanks everyone for bearing with us. I don't see any raised hands. Like Chad said, under reactions, raise your hand and then I can unmute you and have you chat instead of typing in the questions. But again, I don't see any right now.
If we're missing any of you, feel free to jump in at this point. And then once Dr. Hall resumes her presentation, we'll pause again at the end of that segment to see if there are any questions. But seeing none at this point, Dr. Hall, if you want to carry on.
Sure. Okay, so I'm going to get into this re-estate of Le Galley. So I have a pretty brief presentation about this case prepared for today. So I'll just get into it. So I'm going to start with a factual summary of the case. It's a 2017 decision of the Supreme Court of Canada. It's one of two BC cases that really deal with the new gift to witnesses provision that is contained in WESA. So putting my material together for the students this time, I thought that first of all, this was an interesting case because it does deal specifically with that provision, which was the subject of one of our lectures, but also because it discusses this question of whether compensation for an executor or an executrix that's given in a will should be considered as a gift and therefore subject to that gifts to witnesses provision in WESA. And as I was reading the case and discussing this with the students, it occurred to me that this is the kind of characterization of executor compensation that wouldn't be intuitive or obvious to everybody. And I think that it's an extremely important point to realize, and it can have significant implications. So that's why I thought this would be an interesting case for us to talk about today, just to make sure that everybody is aware of this nature of executor compensation and the fact that it does indeed become subject to this section of WESA. So these are the facts. Here we had a lawyer. So I've identified the lawyer here as I, who was a witness to the testator's will. Testator is T. Now, this is a fairly significant estate. It's worth about $1.5 million. T is unmarried and has no children. Her will is a simple will, and it divides her estate among a group of charities. So we've got 6 charities. So I is appointed as the executrix in this will, And the charge clause in the will gives I what is described as the normal fee as compensation for administering the will. And so I thought it might be useful to really identify what this normal fee actually is. So here, this is $38,950. So the key issue here is whether this executrix fee should be considered a gift. Is it a gift for the purposes of the gifts to witnesses section of WESA? And the answer here is yes, possibly surprisingly. Again, one of the reasons why I thought this would be an interesting case for us to talk about. So what does it mean for the executrix fee to attract Section 43 of WESA? Well, Section 43 provides that unless a court decides otherwise, a gift in a will be void if it is to a witness, to the will maker's signature, or to the spouse of that witness. So what this means here is that unless the court declares otherwise, the gift to our lawyer I here will be considered void. Now, Section 43 goes on to say that on application, the court can declare that a gift to a person referred to in subsection 1 is not void and is to take effect if the court is satisfied that the will maker intended to make the gift to the person, even though the person or his or her spouse was a witness to the will. Now, Section 43 modifies the harsher rule under the Wills Act, which said that a gift to a witness or to the spouse of a witness would be void. So Section 43 does ameliorate the consequences of that by allowing the recipient of that gift to apply to court and ask for this declaration. But as I always tell my students in the personal planning course, although this remedy is now available, you obviously want to avoid, if possible, the time and expense of involving individual in the process of having to bring an application to court and seeking a declaration of this kind. So the fact that WESA has kind of lightened up some of these harsher rules doesn't mean that they're no longer important or that this is something that we no longer need to pay attention to, because the expense, hassle, time of having to bring this kind of application is something definitely to be avoided if possible. Okay, so those are the facts, that's the issue, that's the law, and now how is it applied here? Well, the beneficiaries, so remember the beneficiaries here are the charities, argue that because of I's long experience as a wills and estates lawyer, she really should have known better. So this was not the case of a homemade will being made by unsophisticated and unexperienced persons with no understanding of what the consequences of what they were doing would be. The court rejects that as being the central issue here and instead poses the question as one of the testator's intent. So regardless of I's sophistication, did T actually intend to make this gift to I? So of course, the reason why we have rules around gifts to witnesses being void is because there's suspicion there that the gift is unreliable in some way because of the involvement of the recipient of that gift in establishing the validity of the will by acting as a witness. So if that's the central question, how is it answered? Well, this is the kind of evidence that the court looks at. They see that I had actually done previous legal work for the estate of T's mother. that T was a businesswoman, so she herself was a sophisticated will maker, and she would have been more than capable of understanding this simply drafted will that I created for her. And that after this will was created, I did subsequent legal work for T, creating her power of attorney documents, for example. So again, given that T was a sophisticated will maker, establishing that, yes, she knew what she was doing and that she was satisfied with the terms of this simple will that she had created, which included this compensation for I that's treated here as a gift. So T's continuing professional relationship with I illustrated the trust and confidence that T imposed in I, and provides further support for my conclusion that by the charging clause, T actually intended to make a gift to I. So a declaration, the court does make this declaration that the gift created by the charging clause in T's will not be void and is to take effect. Why? Because the court is satisfied that this was T's intent. So what's the takeaway from this for you, I think, is to understand that a charging clause will be treated as a gift to a witness, and that best to avoid the difficulty, if possible, of requiring an application to court of this kind. I think that's the ultimate takeaway. And then secondarily, that if an application of this kind is necessary, this is going to be the central question. And this is the kind of evidence that the court will consider significant in answering that question. Okay, well, that concludes my brief discussion of the estate of Le Galley. So I'll wait and see now if anybody has any questions.
Thanks, Dr. Hall. I've got Sally raising her hand, so I'm just going to ask her to unmute and let her speak.
Yep. Hi, Margaret. Good to see you again.
Yes.
I'm just to verify, the easiest fix for this would have been to not witness the will, just to have two other people in her office actually witness the will.
That's right, thereby avoiding having to bring an application.
Yeah.
Okay. And so that's why I think it's important to bring to everybody's attention the fact that a charging clause will be treated as a gift. And I suppose letting people avoid the difficulty from arising.
And for new notaries like our cohort and the ones following after, I don't think it will really affect us that strongly because the society isn't doing the executor course anymore. So we won't be able to be executors for wills. So yeah, great, thank you.
Thanks, Sally. I've got Brian. I'm just gonna get you to unmute and go ahead, Brian.
I was wondering about the income tax. I understood that executor fees are considered something earnings and not a gift for income tax purposes. Is that correct still or not?
Well, that's interesting. And that could be the case. And I don't think anything has changed about that. But for this purpose, for WESA purposes, it will be treated as a gift.
Got it.
Yeah.
Thank you. Ron, I'm going to come over to you. You should be able to unmute there.
Yeah, hi, Ron here.
Hi, Ron.
Just wanted to comment on Sally's point. Though there is no official executor's course being given, it does not prohibit notaries from being appointed in their personal capacity as executors. Many of our members are appointed as executors in wills, and the key there is to scrupulously keep your work as an executor completely separate from your professional practice as a notary. So I just want to make that comment for Sally. Thanks.
Great. Thanks very much, Ron. And that would have been my my assumption, but I thought there might have been some other developments in the society around that issue. So thanks for clarifying that.
Perfect, thank you.
I see Marnie's got her hand up.
Hi, Marnie.
Hi, yeah, my reactions doesn't have a hand up for some reason.
Oh, okay.
The society has not dropped the executor course. It's just that it's been dropped from the January sessions. But we will be doing it for new notaries, for students. And any member who wants to take it can do so. It is a requirement of the executor insurance coverage.
Hmm.
Why we have to continue providing it. But it is a requirement of that insurance coverage if you are an executor and you want insurance coverage.
Thanks
Thanks,
very much,
Marnie.
Marnie. When does that take place?
Well, this year we're doing it in May.
Okay, great.
So there's a lot of chat coming in, and it's a little bit difficult to manage. So if you can raise your hand to ask a question, I do see someone's microphone is not working. So let me just see. Tia, and I apologize if I'm pronouncing that wrong. My understanding is that where we do act as executors, we have to charge GST on our fees because of our associated practice, even though it is not through our practice. Is that a question, Dr. Hall? You're nodding yes?
Yes.
Okay, thank you. Excellent. Well, is there any other questions from the floor here? Not seeing any hands raised. Thank you for bearing with me as I learn this new format. We're trying to make it a little bit more engaging for everyone.
If there aren't, I'd like to ask a question.
Okay.
So this is my first time doing one of these lunch and learns. I think the lunch and learns are a fantastic idea, and I was really happy to hear from Trista that they happen once every 2 weeks. If there are any other issues that you think would be helpful or suitable as a subject for one of these lunch and learns, then please let me know, and I might talk with Trista and Chad to see either whether it's a lunch and learn topic that I would be qualified to speak to, or I might be able to find somebody else either within the program or even outside of the program that would be a more suitable person to speak to that.
Yeah, thanks. That's a great suggestion, and we'll look forward to having you back as many opportunities as we can, Dr. Hall. I am seeing in the chat section a number of people indicating they can't find or don't have a prompt to raise their hand. So if you move your mouse cursor at the bottom of your screen, will pop up a line which includes mute, start video, as well as reactions. So there's a number there. If you click reactions, raise hand should be one of those options. If not, there's also a thumbs up reaction, and we would accept any of those. If you signal that you have a question, that means that would be helpful. We're not going to be monitoring chat as well as have the open question option. I know someone indicated they didn't have a microphone. I think you got that question, Trista.
Yeah, and I've just, I think your directions helped because Grant has raised his hand. So I'm just asking him to unmute because he does have a question.
Thank you.
Grant, you should be able to chat now.
Oh, thank you. Yeah, my question is when you have a staff notary, what I'm uncertain of is, can the staff notary witness the will appointing, say, myself as the executor with a payment for being the executor?
And whether that raises this gift to witness issue?
Yeah, because I wonder if does the staff notary come under my corporation, or is she independent or he independent because they're a staff notary, even though they're employed by me?
Well, I don't think that question has ever directly come up, but I would err on the side of caution and not have the staff notary act as a witness, because of the possibility that this might attract the gift to witness well.
Yeah, but that's never gone to court.
Yeah, I think an argument could be made that the separation in that case is really an artificial one.
Okay. All right. Thank you.
Perfect.
Trista, sorry, I think I see, I don't think you asked Tammy's question, and Tammy's microphone isn't working. And the question was, and forgive me if it was asked, and Dr. Hall can let us know, if the court considers payment to the executor as a gift when stated in a will, as in charging clauses, is it then considered as a not taxable income?
And it does not necessarily follow that because executors' fees are treated as a gift for the purpose of Section 43. That's how we have to think about it. It doesn't follow that they're going to be treated as a gift for income tax purposes. So for income tax purposes, it will be a fee for a service, but for the purpose of Section 43 in WESA, it's going to be treated as a gift. So it's not a characterization that is going to carry over into all contexts. And if we think about the reason for something like Section 43, this makes sense. This is something I always tell to my students, is that if we understand the rationale or the reason for these rules, instead of just thinking about them, you know, as a set of, you know, kind of rules that need to be memorized and then sort of applied in all contexts, it kind of makes sense to us. So if I'm appointing somebody as my executor and giving them these fees, I'm conferring a benefit upon them, right? And that automatically kind of raises some level of suspicion around the circumstances under which that will was created and the role of this person as a witness who's validating the will. And so the fact that I'm conferring a benefit on this person is what's important here. And that's the reason why it's treated as a gift. And it doesn't lose that character if it's later on taxed, right? So it's still a benefit, even though it's going to be taxed. So I hope that makes sense. Sounded slightly convoluted as it was coming out of my mouth, but yeah.
Thanks, Dr. Hall. I don't see any more questions. Chad, did you want to say anything before I wrap it up here?
No, thanks very much, Trista.
Okay. Thank you, Dr. Hall, for being here. Some great information, and thanks to our members for bearing with this format. You know, shoot me an email, give me a call if you have any questions or comments about it. And our next session will be April 7th. We have due process pro suite integrations with Jennifer Whiting. So look for that in the next newsletter. And have a good afternoon, everyone.
Can I add one last point?
Of course.
When I was talking about the purpose for this rule, kind of connects, I think, with Grant's question as well. And so if we understand this purpose here as really to ensure the validity of the will, even though somebody who is taking a benefit was involved in making that will, if that is really our, or proving the validity of the will, if that's our underlying question, then I think you can see how the identity of this person as a staff lawyer or a staff notary rather than the actual person named as an executor could be considered kind of artificial, right? If that's the question that we're really concerned with.
Thank you.
Okay, you're welcome.
Okay, thanks everyone.
Thanks, everybody. Have a great day.